Okay, I've been informed we're ready to go. I assume that means we are live. So I'd like to welcome the members of the committee, both those here and as well as those online, members of the public here, and I don't see any that I recognize online. And thank you for the staff of the Open Records Council for enabling us to have this room, recording the meeting, as well as helping me print some things and otherwise being of assistance in getting this committee going. Before I call us to order, I'm just going to point out that Ms. Wilkerson is ill. She's our secretary, and we're going to need somebody to be the secretary for this meeting. I've got the little script to read before calling roll. We've got the roll call sheet. We've got the vote sheets. With me kind of running at least most of this meeting, I don't really want to be the one taking the votes or things like that. If nobody else is going to want, and the other big thing would be to do the minutes. If nobody else is willing to take all of that on, I will volunteer to do the minutes after the fact because I'm going to watch the video anyway. So I will do that. So is somebody who is present here willing to do all three, or at least do the Scrivener part during the meeting?
If you could just refresh me on what actually needs to be recorded.
We would need you to record the actual, and I guess there's not a problem. Do you see a problem, Ms. Appelt, with the co-chair also recording the votes? Okay. What we would need to do when you call the meeting to order, you would need to read this little script, and then you would need to just do the roll call of who's present and who's absent. And then when we have our votes, you would need to record the votes as well as the motion and the second, because we would need to do that. So
Sure, I'm willing to do
great. Thank you, Mr. Christopher. All right, with that little piece of housekeeping, I'd like to call the February 2026 meeting of the Advisory Committee on Open Government to order. Mr. Christopher, could you please call the roll?
Certainly. Ambassador Victor Ashe.
I see he has now joined us after we went through to make sure everybody could see and hear. But before you call the roll, would you read that script?
I will. This meeting involves both members participating electronically and members participating in person. A member participating electronically must answer 2 questions for the record. First, can the member simultaneously hear and speak with others participating in the meeting? Second, is the member alone in the room? If the answer to both questions is yes, the member can simply answer yes to both questions. A member who is not alone should identify any other people present in the room with the member. Members participating in person need not answer the 2 questions, but should simply indicate their presence. Please respond when I call your name. Ambassador Victor Ashe. Victor, it looks like you're dialed in, but we can't hear you. Are you able to unmute your microphone? We'll come back to you. Victor, Jennifer Wilkerson, as you indicated, is absent.
Correct.
Chris Cheryl Voss.
Yes, present, and yes to both questions.
Thank you. Alicia Hodge.
Yes to both questions.
Dr. Lee Carter.
Yes to both questions.
Tanisha Holly.
Yes to both questions.
Brian Lapps.
I'm here.
Chief Sammy Williams. Absent. Dick Williams.
Yes. Yes, no.
Excellent. Jonathan Smith. Mark him absent. Dan Haskell.
Present.
Dr. Karen Jackson.
Yes to both questions.
Joel Christopher, that's me. Sheriff Eddie Harris. I will mark him absent. And then the ex officio members, Lauren Lamberth.
Here.
Senator Richard Briggs. I will mark absent. Representative John Crawford. I will mark absent. That's it.
All right. Well, thank you, Mr. Christopher. We have a quorum. So for the first order of business, we need to review and approve the minutes from the November 2025 meeting, which were both posted as well as provided to you before the meeting. Does anybody have any changes or corrections to the minutes?
I move we approve these amendments.
Motion, do we have a second?
I'll
Second.
second.
And I'm sorry, was that Ms., did you get, Joel, did you get who that was? Okay. All right. Would you, let me pause there. Do you think we can do the minutes by unanimous consent instead of a roll call vote? Given, or should we just go ahead and do the roll call vote? All right. Mr. Christopher, could you please call the roll?
Certainly. It's been moved and seconded to approve the minutes. Ambassador Victor Ash.
Yes, can you hear me?
Yes, and let me reverse for a second.
I don't know what the problem is, but
We're
the answer is yes to both your questions.
sure.
Joel.
We're good. Let me reverse for the roll call just to get that
I
on.
apologize for not getting over there today, but I have a funeral to go to.
Nope, no problem. Let me reverse back to the roll call. Ambassador Ash, you're present, and can you answer yes to both of the questions?
Yes, it is.
Okay. And then on the issue of, or on the motion to approve the minutes, how do you
I'm
vote?
a yes.
Okay. Chris Cheryl Voss,
Yes.
and am I pronouncing your name correctly?
Should, close enough, fast. Then ASS.
All right.
Good enough.
Excellent. Alicia Hodge,
Yes.
Dr. Lee Carter,
Yes.
Tanisha Holly,
Yes.
Brian Lapps,
Yes.
Chief Sammy Williams is absent, Dick Williams,
Yes.
Jonathan Smith is absent, Dan Haskell,
Yes.
Dr. Karen Jackson,
Yes.
Joel Christopher, yes. Sheriff Eddie Harris is absent. Do the ex officio members also vote to approve?
There's no reason they don't vote at this point, so yes.
Okay. Lauren Lamberth
Yes.
and Senator Richard Briggs and Representative John Crawford are absent.
Sounds like it was unanimous, so the motion carries. The minutes are approved. The next item on our agenda is the public comment session. I received, as of yesterday afternoon, no written public comments, and Ms. Chadwick is shaking her head, indicating that she has not received in the interim any written public comments. We have received no requests to speak by anybody in advance of the meeting. Is there any member of the public, and it looks like there's one of you here today, who might want to address? Okay, indicating that we have no public comments, either oral or written. We will then move on to unfinished business, or at least new business, because I'm considering the bylaws to be new business, as it was a complete first reading last time, and today we will have the second reading. So moving on to new business, we've got 2 items of business listed, but Mr. Christopher mentioned that he may want to, when we were discussing the agenda, no details other than the agenda, but when Mr. Christopher was discussing the potential items on the agenda, he indicated that he might want to add a 3rd item to the meeting, and because this is a regular meeting, I believe he can do that. So I'll turn the floor over to Mr. Christopher to see if there's a 3rd item that he may want to discuss or put on the agenda.
Yeah, I was doing some research and looking back in January of 2016 that the Office of Open Records Counsel presented a report to the General Assembly just examining issues around fees for inspection of open records and the research that they did into it. And as I've been thinking about the mandate that we have, I think there would be some value in a discussion about sort of baselining where we think that where we think people stand on the issue. It's come up in this most recent legislative session. There was some discussion about altering the method for inspection of records, and in my experience as a journalist in Tennessee, certainly you see a lot of different approaches to how open records are handled, how fees are charged, and it strikes me that there's a lot of discrepancy among public bodies across the state. I think there would be some value in us figuring out what that looks like by surveying members of the public and government agencies and anyone who has interest in the issue.
Okay. So is that a discussion item, or you?
It's a discussion item.
Okay. Okay,
because
great.
Certainly that process could be complicated, and I think it's something we would need to talk about what our role in something like that might be.
Okay, and I understand, just to fill things out, I understand that and correct me if I'm wrong, please, but I understand that perhaps the precipitating event was the introduction of Senate Bill 2540, which would change the rules, the law on inspection of records, and permit government agencies to charge when a member of the public wishes to inspect records, even if they don't want copies. Am I correct on that?
Yes and no. Certainly that put it front and center, but this has been an issue of discussion, I think, for a lot of people who are interested in open records for a long time, that there doesn't seem to be consistent application across the state, depending on the government body that you're dealing with.
Okay, we'll add that as a discussion item in front of the potential need for a conflict of interest policy, if there's no objection to that from the members of the committee. And hearing no objection, we'll go ahead and do that. But now, let's move to the first order of business on which we're hoping to take a vote, which is the bylaws. A draft of the proposed bylaws has been provided as a second reading and for as well as a discussion and a vote. You've received, and it's posted online, both a track changes version as well as a clean version. The track changes version tracks the changes that I have made in light of our discussions from the last meeting. So I think the most efficient use of our time is to discuss the bylaws, perhaps get a feel for where we're going, and then hopefully vote on them. The current, and as the introductory material that I shared and posted online through the Office of Open Records Council says, the current version of the bylaw, that there are two revisions to the current version, and I'd like to talk about them in reverse order. At the November 13, 2025 meeting, we discussed whether ex officio members should be voting members. There was no objection to or even any discussion of any significance about whether the two ex officio members of the General Assembly should be voting members. It seemed to be everybody thought they ought to be voting members. There was, however, considerable discussion about whether the Attorney General or designee should be a voting member. So I'm going to pause there because Ms. Appolt, who is the General Appolt, who is the advisor to this committee who can provide advice, says she may have some thoughts she would like to provide on the legal aspects of those. So with that, I'll invite Ms. Appolt to come up and address the committee. General Appolt.
Thank you,
sorry.
Co-Chair. So in reviewing the statute that authorizes this committee to do its work, particularly 8-4-603A1 and B2, there is complete silence on the part of the legislature as far as which members have voting authority and which potentially would not. And so given the silence in the statute there, the default would be to give every member equal voting authority, whether ex officio or not. we typically look for the legislature to speak and to take away voting authority where it intends to do that. And it does not appear it has intended to do that here. So I would advise against taking away any voting authority from any member, whether ex officio or otherwise.
Thank you. Any questions for General Applin?
Yes. Are you saying ex officios have a vote right now?
The way the law is currently written, that's how I interpret it, yes.
Well, but I think, I strongly disagree with that. I mean, I talked to General Scometti. He didn't think he ought to be voting. I mean, he's your boss. But I just think ask the legislature to give that authority. But I mean, what are we adding? 5 or 6 people that, it just doesn't make any sense.
But we have,
Because they're silent, I mean, everything they're silent on, we just say, go do it.
Well, the
I-
presumption
no
is there's
offense,
authority there, is the presumption because of the establishment of the committee and the membership. That, equal membership, equal votes. So again, the legislature could enact a change to the statute if it wanted to remove voting authority for ex officio members, but as it currently stands, that authority is intact.
Well, no offense, Ms. Apple, I respectfully disagree with, we're going to do this based on a presumption? That's like beauty. It's in the eyes of the beholder. And I think it's open now, but we can ask the legislature to clarify. But I mean, we're talking about giving a vote to 5 or 6 people that we haven't called their name for a vote yet since this committee's been around. And, to be hit with this morning and no prior knowledge to consider it, I think is a mistake. And furthermore, Ms. Apple, this should be in writing. You should give us a legal opinion in writing signed by General Scometti. And if he's not willing to do it, I don't consider it a real opinion. And I don't say any of this to be personally critical. I just say, you come, we're supposed to, the space of 5 minutes, all of a sudden give people a vote that we haven't recognized before? No. And furthermore, it should be in writing and put in the minutes of the meeting.
Can I say something?
please.
All right. I want to be clear. It seems like the previous discussion was on the ex officios, which was not what this is to be. This discussion, I thought, was specifically on the attorney general, whether or not they should be allowed. Am I correct? Because we need to focus on whatever it is, as opposed to the ex officio members.
Well,
we can do that separately.
Okay, we have 3 ex officio members: the attorney general or his designee, and 2 members of the General Assembly, the chair of the Senate, State, and Local Government Committee, that is Senator Richard Briggs, and the chair of the House State Government Committee, which is Representative John Crawford. So there are 3, not 5 or 6, ex officio members of this committee. We discussed last time, and I gave some background when we set this stage. I didn't look at the Attorney General's opinions or anything like that, but I did look at Robert's Rules of Order, and I cited portions of Robert's Rules of Order that provide that as a general matter, ex officio members have the right to vote. So I do consider that to be a written presumption because generally speaking, and as it's included in the bylaws, that unless the bylaws say something different, we're going to follow Robert's Rules of Order. At least I'm going to try to, although I will not always get every detail of them correct. So with that, that is what we're looking at. But there was no serious discussion last time about whether Senator Briggs and Representative Crawford should vote. So I thought there was basically unanimity that the 2 members of the General Assembly as ex officio members would have the vote. Maybe that's not the case. So I was thinking that the discussion would center on the Attorney General or his designee today. So with that being hopefully setting the table, does the committee want to, and you've heard what General Apple has to say on the matter. You've heard what I've said about Robert's Rules of Order. Do we need, with that, I'll just throw it open to see where people want to go with this discussion.
Well, Brian, Victor Ash, I serve on the State Museum Commission. We have 3 ex officio members, President of Tennessee Historical Society and others. They do not vote.
Is that by statute or is that by bylaws?
The statute is silent, to my knowledge. But again, I don't think I've had all of 5 minutes notice on what Mrs. Apple said. We certainly shouldn't act today till we have a thorough written opinion, cite a basis for this, and ask Senator Briggs and the state representative, do they want to vote? What if they don't?
Well, I don't know.
I guess they don't. I guess they show up and don't vote.
Well, I don't know how we're going to ask them, because if they're not here, then I would be asking them about whether they want to vote, which is a matter before this committee, which would be a violation of the open meetings.
Why don't we defer it to the next meeting of this group? And maybe we can get a written opinion between now and then. And you can also talk to the 2 legislators.
Is it proper to make a motion that we at least vote on the question that I understood as to whether the Attorney General would be allowed to vote? I understand that's tied in for your explanation with the others. Or should we just ask for a vote on the whole issue that I think is Mr. Ash is bringing up, Ambassador Ash is bringing up?
Well, Brian, to go back, let's just discuss the AG only. We may deal with issues on open records that affect his office. Like, what articles, what items in his office should be subject to open records, what should not be. I think it's a conflict of interest for him to be voting on it.
Well, is it a conflict of interest for journalists to be voting in favor of as much transparency and openness as possible?
No, because they don't own the records.
Okay,
In
well,
the AG's office, it's under the AG, and he has total authority. The journalist is writing items, and they do not have total authority.
well, I would dispute that the general has total authority. He follows the law, as far as I can tell, which doesn't give him
I
total
understand, but
authority.
Who would you appeal it to if you didn't agree with the AG?
A judge.
Well, then you're into lawsuits, and that's the last thing we need.
Yeah, but that's what the statute sets up if the records are inappropriately withheld. I mean, my view is this committee is inherently set up with conflicts. We're all representatives of certain interests. I expect that those who work for who are journalists or represent the Society of Professional Journalists or the Tennessee Association of Broadcasters or other groups who are not government are going to occasionally have different views, and as a general rule going to favor much more openness than the government, although that's not all the time the case, because no government person that I've talked to believes that we ought to close off the public records or close down public meetings. So I think we're inherently set up with conflicts, but if it's premature to vote, I don't know if the group doesn't want to vote and thinks we need further guidance on this issue. I don't know that there's a point in voting, and I certainly don't think there's a point in voting to adopt bylaws that would prevent the AG from voting if that's going to turn out to be legally problematic, because then we've got to go back and have 2 more readings of bylaws to undo that, and that would just be a mess. So it seems like we've got enough of an issue here that the prudent thing to do, unless I mean, if there's a majority that the AG should vote, then maybe this issue we can move forward. But I sort of hate to put to a vote only if one side's going to win. That doesn't seem the right thing.
Brian. The AG's not here. A person who works on his staff is here, Mrs. Apples. Since he's not here, does she get to vote?
I'm not the representative of the office on this committee. It's Lauren Lamberth.
Well, would
Would
the
you like to speak?
representative who is not Jonathan's committee be able to vote? It seems to me if we're going to say the AG can vote, he's got to show up. He
That's-
can't. Senator Briggs is not sending his secretary.
Okay,
I'm not sending someone.
okay,
In fact, I disagree that I have a conflict. I'm not paid by anybody. I am retired and I have personal views that are well known, but I'm not representing a group that I owe my salary to.
Ms. Lamberth?
okay. I have some thoughts. The statute specifically provides for a designee. So if voting rights are provided to this office, voting rights also pass through to the designee. That is explicit in the statute. And I really would caution everybody to consider me versus the committee as opposed to ex officio versus non ex officio. So if we're considering non-voting rights, I would take the position it's got to be either no ex officio member votes or all ex officio members votes. This 2 out of 3 is pretty suspect, okay? Because now you're singling out one person because they may have an unfavorable view to other people, and that's I do not recommend going down that road. As for my office potentially having a conflict, I would phrase that as a difference of viewpoint. Our office does defend when an agency declines to provide public records, but that is based on an exception that would have been detailed in the statutes. So the legislature has not said that any and everything that's public record needs to be disclosed. There are certain exceptions, and we will defend those when agencies take advantage of those or list them. There are reasons for those exceptions. They are there because the public will benefit more from the exception than from having that record be public. I'm thinking of things like medical records or criminal investigations, okay? Another aspect is that our office also advises agencies when they are required to release records. So we defend when they do not, but we also advise them what they are required to release. And a third point is that me personally, we are subject to the Public Records Act as well, and we receive those requests and field them and respond to them. So there are very many viewpoints that just in this one office we have and we bring to the table.
Ambassador Ash brought up the point about a different state board that he served on in which the ex officio members do not vote. Do we have any sense of what the standard practice is for state boards with ex officio members? Any guidance on that?
Mr. Haskell?
In partly in response to what you said, but partly just to try to have a position on this. I was present when the bill was passed. I think everybody intended there would be 14 voting members, and then there were these other people. But the statute doesn't say non-voting. I think if it doesn't say non-voting, you have to presume they're voting. Our bylaws do not go beyond or adjust or can't withdraw things from the law. If the statute says they're voting, and I think you have to read it to say that, whether our bylaws say they can vote or not vote is pretty much irrelevant. We can't adopt a bylaws that's not consistent with the statute. And one way out of this thing would be to just remove from the bylaws any language relevant to the question of who can vote, because I believe the statute tells us who votes. And that would get us forward to a point where we could then vote on the bylaws and go on about the people's business.
Well, Brian, can I ask the question? Does the AG send a letter to each designated a particular person to be his representative?
Yes.
And is the letter given placed in the minutes? So, I mean, next meeting might be someone other than you. No offense, but
No, it will not. It is done by letter, and that letter is passed on to the Comptroller's Office or Office of Open Records Counsel.
all right, and it's placed in the minutes.
No,
So
it has
why
not
can
been
the
placed in
AG
the
name
minutes.
Why can the AG designate a representative, but Senator Briggs cannot?
Because the statute specifically provides that the AG can do that.
Well, I think they ought to revisit the statute, but I still go back to it. In my mind, it's an egregious conflict of interest, which I know some people disagree with, for the AG to be voting on legal opinions that his designee is providing to this group, and which respectfully, some of us who have been attorneys don't agree with. And when I served for 15 years in the legislature, we always said the Attorney General issues opinions, but it's the legislature that determines whether we follow it. In Tennessee, the Attorney General's opinions, while advisory and perhaps well-researched, do not have the impact of law.
That is a true
In other
statement.
words, the
but we're
governor,
not
we've
the
had
law-
governors
we're
that
not the
disagree with
legislature.
AG.
All right, but that's true that the Attorney General's opinions do not have force of law. They do have great weight, but we're not the legislature. We're a committee that has been appointed by statute by the legislature, and as such, I think we ought to try to carry out the legislative will. It's too late this year, unless you've got a caption bill, that you can find somebody to run on clarifying this issue, but it's a practical matter. It's probably too late, even if there's a caption bill available. So all that being said, we've got to figure out what we're going to do on this issue as to whether we're going to vote today on it, whether we're essentially going to table the issue and seek further advice from the Attorney General's office, or whether we're going to move to amend the bylaws or move to amend that draft that I provided. I'd rather operate by consensus than try to take a bunch of votes
I would
different
urge us
ways.
to put it off. Maybe, Mr. Chair, you'd appoint a subcommittee to look at this issue and come back at our next meeting.
I don't think we
Because there's
have the
obviously
authority.
disagreement.
I think appointing a subcommittee of this group to deliberate towards an opinion and come up with an opinion on what this group is going to vote on would violate the Open Meetings Act, because anytime two or more of us are
Call it a
gathered
task
together,
force and
well, you can call.
sunshine every meeting. I don't mind sunshining it.
Well, I don't think I'm against the task force. We're only 14 of us, so we don't need a task force. And
Okay.
on that is my opinion.
Well,
But-
I think to discuss this for now 10 minutes and act on it when I had no prior notice, no opportunity to think it through, is unfair.
Well, okay. I'm not
Ms.
against
Hodges wants
tabling
to
it.
speak.
I'm not against tabling it, but I would point out that we did discuss this issue in depth last time, and the materials that you were provided in advance of this meeting teed this issue up pretty clearly, I think. But with all that being said, is there any objection to tabling this issue to our next meeting?
I object.
So I had my hand raised,
I'm
and
sorry.
I'll just go ahead and come off. It's okay. I'll just go
Okay.
ahead and come off mute.
Yeah.
So consistent with what I said at the last meeting, I do not have any issues with the AG's representative voting. I think based on the legal opinion that we received from our legal advisor, she just told us that the law supports the fact that the AG's designee have a vote. I am very comfortable with that. I am comfortable with the recommendation that the whole issue about ex officio members voting being removed from the bylaws, because the statute says what it says.
Thank you, Ms. Hodge. And I didn't mean to ignore you, so thank you for coming offline. I didn't see your hand. Mr. Haskell, you were going to say something?
I would prefer that we I think it's time for us to pass the bylaws on second reading. And therefore, I would object to deferring this. And if recognized again, I would move to approve the bylaws and delete any reference to who votes within the bylaws.
I agree.
Is that a
that,
second?
we should, yes.
All right, so we've got a motion and we've got a second, which would be to amend the bylaws to remove reference to who votes. Is there any discussion about that? Any thoughts on that?
I mean, to Victor's point, I am interested in understanding how other similar boards are structured. I also understand the desire to put in place a structure so that we can do the business that we're appointed to do. We've also been not doing that business for many years. So the urgency doesn't strike me as so great that we can't take a little more time to consider it.
Other thoughts?
So I have a couple of comments on that. So I think that from an urgency standpoint, this committee has been criticized because of the issue that you have just put forward. And so I think that we did talk about this at the last meeting. We knew that this was going to be a reoccurring issue with the bylaws because we received the packets. We had a lot of discussion about it. I do not want us to postpone this when we knew this was coming up. And this will just be a further reason for people to criticize the fact that the committee has not been doing what it's supposed to be doing. I think that we can absolutely examine what other committees and boards do from an ex officio standpoint, but that does not negate the fact that our statutory authority does not include the ex officio members as non-voting. So regardless of what other committees and boards do, we have to deal with the statute that governs us.
Thank you, Ms. Hodge. Dr. Jackson, were you getting ready to speak?
No, I'm just ready to go ahead if it's a vote or whatever, so
Okay.
we can move on.
All right, Mr. Williams, were you getting ready to speak? Somebody online was getting ready to speak too.
John, I think we're better. I think we're better off having none of the three. In light of what was said, I apologize for my voice.
I think what I heard you say is you're in favor of having none of the three ex officio members vote. Is that correct?
Right.
Thank you. Thank you. All right. Any other comments or thoughts? My discussion item, I guess, is going to be a question to General Appelt, which is, do you see a legal problem if we just take out any mention of voting or not?
No, as long as there's consistency with statute, it's
Okay.
fine.
So if we took that issue out. Okay, all right. I think we've got a motion and we've got a second. I just want to raise a question before we vote on that. There were two proposed changes. I'm got the motion. I've got the bylaws here.
Could you expand on your question about removing any mention of voting?
Yeah, my question was, does General Appelt think that would cause a legal problem if we took that issue out? If we took I'm looking for the sentences. The sentences we would have to take out would be in section 3J4. We would strike the second sentence that says ex officio members are voting members of the committee. We would just strike that sentence. So does Mr. Haskell, does that capture what you're suggesting?
Yes, sir.
It's just the sentence.
J4.
I'm looking at B1 too here in the red line version. You must be looking at
Oh.
a different version. Let's see.
Yes, it's okay. It looks like it's in two places. It's in, is it section 2A? The composition, three-member ex officio, no. Well, we need to change 2B3, saying voting members are not permitted to name a designee, because the AG clearly by statute is permitted to name a designee. So in the red line of the bylaws, I've suggested that too. Did you not get a red line of the bylaws?
So I'm looking at two different versions of the bylaws. One starts with two membership ABC or AB, but the other one starts with membership CD. I wonder if,
Something got messed up.
wonky here.
It must have been when I tried to combine the files into
Okay.
one document.
Yeah, one says voting members are not permitted to name a designee to attend, and
Yeah.
one says unless authorized by statute, voting members are not permitted.
All right, I apologize. I've made a hash of this by trying to combine the documents, and I didn't proofread the way I should have, so we've got a mess. My bad on that. So with that, you still, I mean, I don't know, it's not going to be real clear what we're voting on.
Mr. Chairman, it's my motion. I would move to withdraw the motion and defer this matter to the next meeting.
Yes, thank you, and I apologize for that lack of clarity on that. I was trying to make things efficient, and I ended up smushing things up and making a hash of it. All right. Thank you for that discussion. We'll defer that to the next meeting. And then the final action item on our agenda is a report to the General Assembly.
Excuse me, so you'll make sure, excuse me, Chair, you'll make sure that we get a unified copy.
Yes, well, I'll get you,
What we should be voting.
we'll provide a proper copy of what we should be
Thank you.
voting on next
And
time
will
around.
General Apple present a written opinion? Or somebody in the AG's office?
You would have to follow the procedure for asking for an official AG opinion if that's what you're
well, what is
wanting.
it?
If you're just
Well,
wanting
what
my advice as counsel, I've given that to you here today. I'm happy to write that up in a memorandum as
Tell
well.
me how does this body, I personally don't have the right to get an opinion, but does this body have the right to? General Apple?
I don't think so, but that's not anything that I was aware would be coming up on the agenda today. I'm happy to look into it for you, but my first just intuition there is that no, I don't believe so.
Well, then, so you're putting, this is unbelievable. You're giving an opinion, but you won't give it in writing. And if we want to appeal it, you tell us we can't do it.
Ambassador Ash, that's an unfair characterization of what General Applet just said. General Applet said she would be happy to put it in writing. There's a difference between a written opinion from an assistant or associate attorney general, I'm not sure what your title is, and an official attorney general's opinion. An official attorney general's opinion runs through, I don't know how much review, and they're fairly rare, especially in recent years. So just because we would even ask for an opinion, I don't know that we, if we have the power to ask for one, I don't know that the general would have to give us one. Do you know that? Does anybody know that?
There's some discretion there. If you want to speak for the office, go ahead. There's a statute that
That's
governs
exactly
it.
what I was going to say. There is some
Are we
discretion.
going to get a written opinion from somebody, even if it's not, quote, official?
I'm happy to provide a memorandum as your attorney, as the advisory attorney to this body. I'm happy to provide a legal memorandum for this committee to consider, to put my recommendations today in writing.
And you were appointed to be our attorney by the AG, not by this board. Is that true?
Well, I work for the Attorney General, And I also serve as part of my role for the Attorney General as counsel. I serve as board attorney for smaller boards that do not have their own staff. So that is why I am here today.
Well, no offense, none of this is personal, but is that a yes or no that you were appointed by the AG?
Well, I work for the Attorney General. I was not specifically appointed to this board in the same way that Ms. Lamberth was appointed, but as part of my employment with the office, I was assigned to work with this board as your counsel.
But Mrs. Lambert is not the attorney for this board, unless I'm mistaken, Ms. Lambert.
That's correct. She is the AG representative.
Right. We're trying to
And
make
so you're So you're the one who would vote, Ms. Lambert?
No, yes, I would be. We're trying to make the distinction clear that I am the designee as the member on this board. I am the member of this, committee. If ex officio members vote, then I would vote. Rachel here is the advisor to the board. We've tried to make that explicitly clear so that no one thought I was advising the board in addition to voting.
Well, I eagerly look forward to the memorandum. And by the way, Brian, I urge you to read Keel Hunt's book called The Coup, when Lamar Alexander became governor 3 days early. And there it was Hayes Cooney, not Bill Leach, who issued the opinion that Hal Hardin used to persuade John Wilder and Ned McWhirter and Lamar to act. And that's contrary to what you just said. Now, it's 60 years later, and maybe things have changed.
All right. Okay. We'll move on to the next order of business, which is the report that we provide to the annual report to the legislature. It's included in your materials. I originally thought, and I discussed last time, that the co-chairs could work on this report outside of committee meetings because the statutory language talks about the co-chairs needing to agree on the contents of the report. When I looked at it more closely, I had more questions about whether that initial reading was correct. So following advice from Ms. Apple, we'll proceed under the understanding that, 1, the committee must vote to approve the report, and 2, the co-chairs must agree on the contents. And because the committee must vote to agree on the report, Mr. Christopher and I did not have any discussions about it outside of that because that would be deliberating towards a matter that the committee would be voting on. So the statute, but the point is that we need to finalize that document here today if we're to provide it in a timely fashion, given that it is due on March 1. Oh, and the statute does call for a detailed report, but I don't think we want so many details in the report that the individuals to whom it is addressed won't read it. So I've tried to hit the highlights in the appropriate level of detail. I will also note that we'll need to make revisions to one of the paragraphs about what we've done specifically regarding approval of the bylaws. And with that, I'm just throw it open for discussion about contents of this report. We would need to say that the committee then discussed bylaws for a second time.
I certainly concur that we don't need to get to a level of detail that's overwhelming for the audience that we're trying to reach here. And I think you've hit that level of that in the draft.
Okay. All right, thank you. Any other?
I agree.
Okay. All right, great.
I agree.
All right. Anybody disagree? All right, then hearing none, what I propose to do is change on the first, second, third, fourth, fifth paragraph on the first page. I will change the second sentence to say, the committee then discussed bylaws for a second time, period. And then I will strike that clause about to be confirmed or edited as necessary. With those revisions, do I hear a motion to approve and send this report?
I so move that this report be accepted and passed on.
Thank you, Dr. Jackson. Do we have a second?
I'll second.
Thank you, Ms. Vass. Mr. Christopher, could you please call the roll?
Ambassador Victor Ash,
I abstain.
Jennifer Wilkerson is not present. Chris Vass.
Aye.
Oh, I'm sorry. You were the second. My apologies. Alicia Hodge,
Yes.
Dr. Lee Carter,
Yes.
Tanisha Holly,
Yes.
Brian Lapps,
Yes.
Chief Sammy Williams is not present. Dick Williams,
Yes.
Jonathan Smith is not present. Dan Haskell,
Yes.
Dr. Karen Jackson made the motion. Joel Christopher, yes. Sheriff Eddie Harris is not present. Continue through the ex officio.
Yeah, if they're not here, you don't need to call them.
Sure. All right. Lauren Lamberth.
Yes.
It sounds like we have a majority, so the motion carries. Thank you, members of the committee. So, Mr. Christopher, because I'm the one who has this on my computer, with your permission, I will go ahead and kind of write in the word sign, S. Joel Christopher, and S. Brian Lapps, and I will get this submitted tomorrow or today or tomorrow. Is that acceptable?
It is, yes.
All right.
And
Thank
can I ask you, Brian, what you submitted, who did you submit it to in the legislature?
All of the people who were listed on the letter, which I will, let me find it.
Well, my reason for asking is, why don't we just send it to all 132,
Because
the 33 and the 99?
because the statute tells us who we submit it to. And
Well, submit it to them, but it doesn't prevent you from, to other people who have a role.
well, we've just approved the letter, and it's submitting to Governor Bill Lee, Lieutenant Governor Randy McNally, Senator Briggs, Senator Akbari, because we talked about last time sending it to the minority leader, and Speaker Sexton, Representative Crawford, and Minority Leader in the House, Karen Camper. Certainly, if anybody on this committee wants to send it, then you'll get copies of it too. If anybody wants to send it to all of the legislators, you're certainly free to do that. Okay, that concludes our action items. And as we discussed at the beginning of the meeting, Mr. Christopher wanted to bring up an issue of discussion about open records or public records in general. So I will turn the meeting over to Mr. Christopher to lead the discussion on that and on what he wants to discuss.
Yeah, to circle back what I mentioned at the beginning of the meeting, as this committee reforms in some fashion, it seems to me that we need a better understanding of the state of open records across the state. And I think there would be value in having a discussion about how we would achieve that baseline knowledge. So I'll just open that up to thoughts from other members of the committee. I can expound on that. I mean, 10 years ago, there was a great deal of research surveying individuals, groups, government agencies to get their input about, in particular, about open records. And using that knowledge, there was a report created that explained how Tennessee compared to other states, some suggestions on best practices. My sense in 7 years as a journalist in Tennessee is that there are differences in application that have come to be depending on what the agency is, who the requester is. It makes sense to me that a periodic survey of that, a census of how open records are applied and enforced throughout the state is valuable. It's a chance to understand whether the people charged with with following the law or following it well, and whether there's problems that have arisen as technology changes, as the laws that were in place at the time have changed. It seems to me that it's good for us to periodically baseline what the state of open records are in the state.
I think Ms. Hodge has her hand up.
Thank you. So my question is to our legal advisor. What authority do we have under the statute to do what's just been described?
I think we would need to go back to 8-4-603 and take a look at that. Let me grab it.
Ms. Hodge, I think I'm sensing as the former Open Records Counsel, you might have a thought on what you think that ought to be. I'm sorry, I jumped into chairing the meeting after I turned it over to you, Joel. My apologies. I'll be quiet.
No concerns.
I think the statute itself is written pretty broadly here. The advisory committee shall, with the guidance of the Office of Open Records Counsel, hold meetings to review and provide written comments. It says if requested on any proposed legislation. So I guess the only thing that's missing here is the request.
Does it say who has to make the request?
It does not.
So it could be any citizen in Tennessee or a member of the, we don't know then, do we? Is it any of the 132 legislators or the governor or a person walking down John Lewis Street? I'm being serious. I mean, it says requested. So anybody can?
I think that's a good question. How have we taken requests in the past, or if at all?
I don't think we've had them.
You have one? Okay, that'd be great. Yes. Member of the public here.
If it's
Come up to the mic.
okay.
Can't hear you.
Go to the other mic.
Okay. Just in answer to that question, just because I have information about it, I think it was the part of the statute she's referring to is when there is a request to review legislation, and that there are other things in the statute that ACOG is allowed to do in terms of advising the Open Records Council and the policies and schedule reasonable fees and all that kind of stuff. But what you're referring to in statute is about looking at legislation, and that did occur in, I believe, 2019, or because I think the report came out right before COVID, but if I'm wrong, it was 2018. But I do know what it was about. It was about looking at a proposal to have confidentiality in the hiring process for the top people in higher education. And there was a report that was produced at the time. I believe Carrie Whitworth was on this ACOG board, and Adam Yeomans was at the time the representative for TCOG. And I think that is the only time, I think, that I can recall that there was a legislative request. But I do think the advisory committee, when it was first established, the purpose was, one of the main purposes was to provide feedback on the development of the schedule of reasonable charges and all the other policies that the office put out. And they did do that. And I think it's supposed to be looked at annually. And then the other thing, last time that they gave feedback on Office of Open Records Council policy was when there was legislation passed to require all government entities to adopt a policy. And the Open Records Council, who I think was Ann Butterworth at the time, proposed a policy, and the advisory of committee reviewed that and gave feedback to her about that, which then she decided whether or not to incorporate that into the policy. So that has been the more frequent role of ACOG, has been to advise on the policies, the forms, the schedule, all of those kinds of things. And what was really one of the main intentions when ACOG was formed. So that went a little farther, but maybe it offers some perspective.
Just for the record, could you identify yourself?
I'm Deborah Fisher, and I'm the Executive Director of Tennessee Coalition for Open Government.
Thank you.
And so I'll just say, I'll add to what Deborah said. As far as surveying is concerned, what really prompted the Office of Open Records Council to be established was a survey that was done by some of the associations in this state. What I know about the history of the advisory committee is that the advisory committee has not conducted surveys. TCOG was very instrumental in that initial survey that was done, that set up then Governor Bredesen establishing OORC.
So if I'm understanding correctly, then we fill a very passive role in that it requires somebody to come to us as opposed to us acting proactively to address some of the issues of open government.
That's how I read the statute, but, well, I'm sorry, was somebody else going to say?
Brian,
Yes, sir.
when General Adams read her, she said, a request is made, and I asked who has to make the request. We got an answer as to who has made them in the past, but is it correct that any citizen could make a request on a pending bill? I mean, that's someone introduces a bill and citizen Y in Tullahoma wants to comment on it. Can they send us a letter and request us to look at it the way the law is written?
I suppose.
Well, then to answer the question, I could make the request. I'm a citizen of the state.
I mean, the law is very open-ended. I will say, you are created to provide guidance and advice to the Office of Open Records Council, and you serve with their guidance as well in responding to those requests. I would imagine that if the Office of Open Records Council got a request, they could funnel it over to you to consider and to assist them with responding back to the individual as well. So putting kind of all of the pieces together, that's how I would envision ideally it would work.
Well, I'll just make the general comment that I think we should provide more specific information either in the bylaws or on our website, which says what requirements are and where would you send it to if a citizen wanted to make a request. Because the way the law is written right now, any citizen in Tennessee could make a request. Now, he may not like the answer, but they can make the request. And it can't just be put in a wastebasket.
Is the scope of our advisement limited only to pending legislation?
So with respect to requests from the governor or a committee of the General Assembly under B2, the advisory committee shall provide reports on open records and open meetings laws and issues. That's a little bit broader there, but that's again at the request of the governor or committee of the General Assembly. Whereas the other section we've been looking at is just simply requests for, an opinion on proposed legislation.
Well, once you have time to think this over, give us a memo or something as to what that really means? Because I don't think we really have an answer yet.
I think it's also up to you as a governing body to decide what it means for you as far as how you want to receive requests too, because the legislature doesn't set out a particular procedure. I mean, I would definitely keep in mind the relationship between this committee and the Office of Open Records Counsel, and what is explicitly written in statute. But to the extent that it really doesn't set forth a way that requests come to you, I think you do have some interpretation there. Is there an appetite for opening up requests to the public to come before this body and ask for advice? I mean, is there an appetite to do that?
With all due respect, I don't think it matters whether there's an appetite or not. The law says a request made. Well, it doesn't matter whether we're hungry or not. It just means can someone make a request and we have to look at it. It's vague.
So reading the two statutes together, 602 and 603, anyone can make the request, or giving it a broad reading, anyone can make the request, but the guidance goes to the Office of Open Records Counsel. It does not go to members of the public directly.
But wouldn't it be an open record? So anyone in the public could get a copy of it?
Sure, I'm just saying that it's not advice directed to the public. It is advice directed to the Office of Open Records Counsel, presumably what they should or should not do in that context.
And I'd also want to be careful about taking on things that are specifically within the role of the Office of Open Records Counsel too. I mean, my understanding is the public primarily seeks information from the Office of Open Records Counsel because that's what the whole office is set up to do. So I would want to be careful about trying to duplicate efforts or usurp efforts or render advice to the Open Records Counsel that might not be wanted.
I guess to refine what I'm thinking here is that among the public in particular, I think we have to acknowledge that there's a knowledge gap in what the law provides, and I think that gap extends to a lot of the public agencies that the law governs. Without understanding how the law is applied and whether it's applied consistently across the state, I think we have a hard time identifying what the important issues are in open government. So I'm suggesting that there would be value in periodically surveying the state of both those questions. So is that a request this body could make to the Office of Open Government?
I would think with a motion, a second, and a vote, we could make that guidance as a group, so long as the vote was to make that guidance.
I'd also point out, I don't think we have this. We don't have any staff. The people who would have to do that would be the Office of Open Records Counsel, if the Office of Open Records Counsel wanted to do that, because I don't know how we would do that as a group. Certainly individuals with the groups that they represent could do things like that, as I've heard has previously been done. But I just don't know logistically how we would do that.
is there a way for us to hear from staff in the OORC about if there's a mechanism that they currently use, just kind of to gauge what the issues are? I mean, we know that their annual report is posted online, and it has a breakdown of the types of calls that they get. We know they do a lot of training, so I can imagine that they hear when they are engaged in all of these different activities what the issues are across the state.
Tony Chadwick, Open Records Council. I think that one of the things that sort of gets overlooked sometimes is just how incredibly busy the office is, especially around this time of year. The annual report lays out all of the inquiries that were received and answered over the past year. And you can see if you track those over the last few years, it increases every year with the number of inquiries that we get. We do have a good pulse on, what issues we're seeing repeatedly. I don't know that there is a broad sort of steady same thing going on. So in other words, we'll have 1 million questions come in. Obviously, that's an over-exaggeration, but we'll have several questions come in about AI and governmental entities getting requests for records for their AI histories and things like that. We'll have several of those come in, and then that will kind of drop off. And then suddenly we'll have a new issue that pops up where recently we've had a lot of questions about power of attorney being issued from a Tennessee citizen to an out-of-state requester for the sole purpose of being able to request records on their behalf. And so we'll have all of the governmental entities reaching out to us, asking us if that's valid or if that's something they have to accept. And then, it will be, with citizens, it's generally pretty steadily, why was my records request denied? Or why have I not heard back from this governmental entity that I submitted the request to? So that's all of the citizen requests are going to go mostly into one of those two buckets. There will be a few outliers, but usually those are the two issues with citizens. And then again, with governmental entities, it's just whatever is the new sort of thing that they're facing each month or after several weeks, it will change to something entirely new or entirely different. And we'll have those threads kind of continue. We'll still get requests about AI now, but mostly that's dropped off. So I think with our annual report, it really does provide the best information about just how our volume is looking. If there were specific questions that you all wanted us to look into or anything like that, I would be happy to take that to the general counsel and see depending on what the request really is from you all, what our ability and time would allow us to do and whether we could really respond to that in a meaningful way at all. Does that answer the question?
What about your ability to review the schedule of reasonable charges, for instance?
So I think they looked at that a second time several years ago and found that with the cost of paper, printer toner, and all of those things, it's still fairly relevant and still on point for what it costs a governmental entity to make copies. The labor charges are the labor charges where I'm not sure that they would change. It really is just what it costs for the person who is performing the task, what they get paid hourly, and how many hours they put into the request.
You said they conducted a survey of some sort and found those charges to be reasonable?
I don't want to be incorrect in this answer. I have only been in this role for a few years. It hasn't happened while I've been in this role. I've understood from the person who was here before me that was something that happened, but I have no personal knowledge of that.
Is there any mechanism within the office to periodically look at those issues to see if there are discrepancies among government agencies that are performing similar tasks? How do you know whether it's being applied equally by everybody that's in a similar situation? Are you relying only on somebody contesting that?
I'll answer it from what I know, and I'll make off. First of all, I'll say that if the Open Records Council wants to change the schedule of charges, I think it's statutory that it comes to us for opinion on that. So there is that. But I'll just look and say, from my experience, representing the community colleges and technical colleges, we have 13 community colleges, and now we have 23 technical colleges. They're not all on this, and nowadays, most of the records requests we get are not to go look in a paper file. It's to go find things and to perhaps pull things out of documents as long as it doesn't create a new record and that kind of thing. So I don't know that there's consistency in how much time it takes across even our agency to do that, because they keep records differently. They put them in different places. They have different record systems. Some are older, some are the newer. And if you made the same request, if you made a detailed request from each of our colleges, you'd probably get a different schedule of charges on how much time it would take each of them to do it, just based on how they keep their records and how they assign responsibility for keeping records, because at one college, one person might be able to do it. Another college might have 4 people need to do it. So I can answer with that anecdote, which doesn't address, I don't think, your whole question, but that's an anecdote that I think might be relevant.
Certainly gets to part of the question, I guess. You're pointing out what I think is a source of frustration for those who are seeking open records, that there is no standard beyond the general standard of what the labor costs are and reproduction. You can certainly envision scenarios in which a public agency would purposefully choose to keep records in a form that makes them difficult to search, to throw up barriers to people acquiring what should be public information. And I think as someone from my perspective who's on the other end of often requesting documents, the responses that you get from various agencies are wildly differing, right? As are the costs. That seems to me a flaw in the system, that any citizen of this state who's requesting an open document should have a baseline expectation for how that search is going to be conducted, what the cost looks like beyond what's expressed in the law as it stands now.
Well, I can say from 15 years in higher education at state agencies, I've never heard anybody say we need to throw up barriers in how we keep records to do it.
And please let me.
Yeah,
I'm not suggesting that anybody has done that, but you could envision a scenario in which that could happen.
Yeah, it's possible, but my experience is that I am familiar with the frustration of our being able to get the records that we want for our internal management purposes and how they're kept. So we try, sometimes better, more successfully than others, to try to make it easy to get the records and to share information internally. And if you look on our website, there's a lot of information out there that we do provide regarding higher education, and that we're quite proud of providing. So we're constantly trying, and I don't know that it's unique to the Board of Regents, trying to make our records administration more efficient, so that we can be more efficient in doing our jobs. So that's I bring it. That's the perspective I have, but I feel like I'm dominating conversation again.
I feel like what you're calling out is the fact that different agencies have different ways to store their records. I don't want to say it's unfortunate, but we don't have one centralized location to store everything. So it is going to be different based on each agency. So the best we can do is have, say, a floor or a ceiling, and within that to have discretion. So I think that's what we've done. We have this schedule that is like, generally, this is what it's going to be, but it may take longer to search at TBR than it takes at our office. So I guess my point is I think we're as good as we can get on that front, and more specifically on your question about how will we know if there's consistent problems. That's one of the roles that the Office of Open Records Counsel is fulfilling. They receive these inquiries from all over, not just one, they're not unique to just one entity. So all the public will route through Office of Open Record Counsel, the issues, So that would be the best way to say, hey, we're seeing this type of issue now or this type of issue in the future.
So based on that, though, how often are you compiling that information and sharing it publicly, where you're seeing specific issues, and what is the action that comes from that?
Sure. So when you say do you mean my office?
I do mean your
Okay,
office,
so,
yes.
Well, we don't, that is not one of our functions. That is the function of the Office of Open Records Counsel. So that would be something that would happen in her annual report. So that's what she just reported on.
Sure. Okay. I understand. Yes. My apologies. I actually meant.
Okay.
I meant your office. I guess what I think I'm expressing is a frustration by those who consistently seek open records to not getting the same response, which I understand it depends on the agency, right? But if we're seeing these wide variations in speed, in cost, in thoroughness, in objections that are being raised, then clearly there's a problem. The system isn't working equally for all people. Sure, there can be some variation. As you mentioned, we're looking for a baseline of that. But I don't think I'm speaking for myself or for my experience to say that if we surveyed people across the state who have had the experience, they would tell you that the inconsistency is a flaw in the system. And I'm trying to get at that. Is there a way that we can identify what is causing these great inconsistencies in responses and speed and costs, and provide some information for decision makers about whether that should be addressed legally?
Is that the purview of this committee? Of course, there's going to be inconsistency, and I'm coming from another state where I remember that and what it takes, and we had to create a new open records law because of something. I mean, any day, especially with new things happening, AI, there are going to be inquiries, and we won't have a timeline. So I'm just wondering, this sounds to me like a research project for a PhD student.
Or for a government agency, which does have the resources to do that and has done it. And the report that I referred to when I first brought this up from January of 2016 from the Open Records Council, and it was initiated at the request of legislators, certainly, but they did a statewide survey with advice and guidance from the Advisory Committee on Open Government. They developed online surveys for citizens and for governmental entities. There were 407 citizen respondents, 235 government respondents. And with the advice and guidance from ACOG, they created a report that really identified what many of the issues were around fees for the inspection of open public records. It's been a long time since anything of that scope has been conducted in Tennessee, and I come back to the point I keep making. There are discrepancies. If we don't know what's causing those discrepancies, you can't fix the issue. You can't fix the problem. And there is a problem. There's no question about that. Maybe it's in the ability of small agencies to keep records. Maybe it is that there are intentional hurdles. I don't know. I can't say that for sure. But without some periodic review of how the law is actually being applied, how do we know that we're effectively following it And if that's not the role of this group, I'm not sure what the purpose of it is, other than to sit back passively and wait for us to be asked questions about legislation that's being proposed. That's a perspective that serves really only the government, not the broad citizenry.
Hey, Joel, this is Chris Vass. Hey, this is frustrating. I think there needs to be a re-review of the schedule of fees. I think there's wide inconsistency with who agencies assign to actually review records. It's supposed to be, maybe not the most expensive nor the most cheapest employee in an office.
Mr. Ash, could you mute yourself if you're taking another call?
Chris, if you want to continue, please.
Okay, I wasn't sure if he was on and I was on. Sorry. I just think that, when I know at the Times Free Press, when you make a request to the county or the city, and all of a sudden it appears that they've assigned an in-house attorney to go through the records. Well, all of a sudden the cost per hour goes up to $120 instead of $20. Well, that gets prohibitively expensive, So I don't know how you corral that. I'm sure there are reasons that agencies would say, well, an attorney needs to review this for redaction purposes. But I think the inconsistency is crazy. And I think it has a chilling effect. And I think we all know the reasons. There's either ignorance, which is fixable, I think, to a point. And I think there's obstruction. I don't know how you fix that.
Certainly challenging to fix it without knowing the prevalence of the problem, which is the point that I'm going to keep making. That
I think it's pretty prevalent.
So I think there's a distinction between, say, for example, figuring out the problems, us doing that, and then us advising that someone else explore how that could be done. So I think we have the ability to say, hey, we think this is a valuable effort. Could you look into how this could happen, how we could replicate this kind of study?
I think that's a wonderful starting point. Again, I think gathering information about how the law is applied certainly, in my view, falls within the scope of what this committee exists to do. And it's a valuable effort. It's been a long time since we've done anything like that, right? So it's hard to provide advice if you don't understand how the law is working in practice.
Let me ask, who did do that last one?
That was Ann Butterworth from she was at the Open Records Council. And I will provide a copy of this, obviously, for all the committee members to review. I think it gives you an idea of the value of the kind of information that I'm suggesting would be useful to this committee as it provides advice.
So this was 10 years ago, Joel? 2016,
That's
said?
correct. It was the report made to members of the 109th General Assembly on January 15th, 2016.
Well, no, I think you've raised an extraordinarily valuable question. I mean, you didn't even go local government, whether it's county or city. And I mean, Knox County, we have a sheriff's department independent. We have a school system independent. You have others independent. I suspect they all have different ways of complying with the law. There's no consistency between any of the three.
That's
That's just
correct.
in one county in Tennessee. And we have legislation pending to require local governments to do surveys as to how many illegal immigrants we have or immigrants that don't show citizenship, and how's that going to be carried out? Is it going to be open to the public? Will it be done the same in Wilson County as it is in Knox County? My guess is no, but that doesn't keep the legislature from coming up with more records that might not even be open for public review.
Yeah, and I'm not suggesting we focus on particular efforts at gathering information as you referenced there, but a broader survey of the state of open records in Tennessee, I think it would be tremendously useful to the government that's charged with either following those laws or making sure that they're followed, and to this committee, which is charged with offering advice on any legislation that might be before the legislature.
Well, I remember well before 2016, the Tennessee Press Association asked member papers to, I think there was, we all sort of agreed on what the request would be, but member papers actually went out to various agencies in their readership areas, submitted FOIA requests, and then tracked how long it took to get back the information, and was the information complete, et cetera, et cetera. But I mean, that was a long time ago. It was, probably late 2000s. I mean, there are ways to do surveys like that. It's an ask of outlets, but that's possible.
Indeed, and there's value in that, and that speaks to, I think somebody mentioned the point, there's nothing that stops organizations or individuals from doing this themselves, but certainly those organizations don't have the same ability to survey the actual government agencies. To Brian's point that there are complications and complexities that agencies face too, that they may be more willing to speak about if they're part of a broader survey of the issue. And obviously with the technological changes that are always occurring and are certainly going to occur at a rapid pace with the introduction of artificial intelligence into everyone's operations, we're going to have a whole host of issues in front of us that aren't there right now.
And so are you going back to the recommendation that we as ACOG send the survey out?
I think that it's a discussion, right? So, what spurred me thinking about that was the fact that, the Office of Open Records Council conducted a survey specific to issues surrounding fees for inspection of open public records. But I think we could certainly identify some points of friction that would be worth surveying, and my recommendation would be that be conducted by the Office of Open Records Council, as it was in the case of when there was consideration of fees for inspection of open records.
So my recommendation would be that we make the request that Tony said that she was willing to make for us, that that request be taken to their general counsel to see what resources they have available, that they come back and then report to us what that conversation was, and then we can make a decision at that point.
And we could certainly use as guidance from the Office of Open Records Council the friction points that it has identified over some period of time. So, where are the most complaints? Where are the most, when are they called upon most often to intervene? That'll give us some guidance of some of the issues that are arising. to my knowledge, I could be incorrect here, I don't know that any of us could right now say, you know, if looking at the scope of issues raised by the citizenry, it's clear that there is an issue that arises consistently around X. I think that would be incredibly valuable to have that knowledge. And I think it'd be valuable for the legislature to have that knowledge. So, yes, to your point, I think maybe asking the Office of Open Records Counsel if it can provide that information, and if not, what it would take to acquire that information. And maybe I'll
So have we
punt it back to you.
So have we made that request, Ms. Chadwick?
Tony Chadwick again. You can make that request, certainly, and I would be happy to take it to the general counsel. I think in the discussion that I've heard a lot of generalization. If you want to make a request of our office to conduct some sort of anything, I would want maybe as specific as possible as exactly what you're asking of us, so that when I come back to the next meeting, I can provide valuable feedback on what we could or couldn't do, but just very as specifically as possible what you're asking of us, so that we can make those determinations as far as resources and availability of that.
That makes sense to me. So following that point, what would our process be for submitting a refined and specific request?
Well, I guess, let me think, I'm a little bit thinking through this aloud, is because this would not be something we would be voting on. I think it would be something that co-chairs could discuss. Could co-chairs, is this something we can do out of committee, or that seems, okay.
Well,
Business
Mr.
of the
Christopher
committee.
has, the most knowledge and apparently interest in this. Together, I don't know if you could compose a more specific proposal, bring it back to this committee if that's what it has to do, or send it to us if it has to be done in between time, so that they can work on it, and then we can have a more cogent discussion on September 21st. But it's clear, without everybody responding, that the knowledge base or the concern about it rests with the co-chair, and in this case, Mr. Christopher. So I would go ahead with that request, composing a specific request.
That sounds reasonable to me.
Sounds reasonable to
Is
me
that
as
our
well.
next meeting, September 21? Did I hear that correctly?
That's on our calendars.
Are there any other meeting scheduled? Is that the one on 21st?
We had discussed that because of all the varying schedules in the summer, as I recall. So that's what was voted upon in the last meeting.
Well, I don't know if it does, but I would remind you that's the time of the year when the Jewish holiday of Rosh Hashanah and Yom Kippur take place, and we should not be meeting on one of those days. It may not be, it may not conflict, but we should keep it in mind that they come in September,
Agreed.
and somebody can easily research it.
Agreed. But would you go ahead and act on the other, please? If that's what we're going to do, the recommendation,
Yeah.
so we can get some closure.
Yeah, do we need a motion to?
And we
I
don't
think-
need a motion there. So we can go on
we
to
good. Okay.
next order of business. I'll turn it back to you.
All right, thank you. Well, the next order of business is, I think, setting the discussion items for next meeting. One of the discussion items we had for this meeting was the potential need for a conflict of interest policy, but I think we've met long enough and probably can punt that one to the next meeting. So without hearing any objection, we'll punt that. And now the suggestions, we've got at least one suggestion for the topic of the next meeting is a recommendation for information from the Office of Open Records Council. A second topic of conversation, or second suggested topic, is the election of at least one new co-chair, because my appointment is scheduled to expire on October 31. I will serve until I'm replaced, but as of October 31, there very well, or November 1, there could be a new representative from higher education. Traditionally, it would roll to the University of Tennessee system to nominate, and the comptroller to select somebody from the UT system. So we should not assume I will stay beyond that time, because we might only then have one co-chair and no ability to call the meeting really easily. So that will need to be a topic of conversation at the next one. And I just looked while we were talking about holidays, September 21, 26. We've got International Day of Peace and World Alzheimer's Day. So I think we're good from Yom Kippur and Rosh Hashanah. But this,
I think
I'm sorry.
Yom Kippur.
No,
is
Yom Kippur is
21st.
well, that's what
Right,
good.
Yom Kippur is September 2021.
Well, that's what good AI does, yeah. So
And Rosh Hashanah is September 11 to 13. I would strongly urge you not to conflict with the Jewish holiday.
I'm in agreement with that. So shall we look for a different day in
Well,
September
move it
that
to
we
the
can?
move it to the 22nd, unless it's a Saturday or Sunday.
Do we know whether the room
It's
is
a Tuesday.
available on Tuesday, the 22nd?
Well, we can find another room, surely.
Well, we've got to have the
Legislative
staff.
committee room.
We've got to have the staff from the Office of Open Records Council to help us comply. So we really need the support from them. Yes. Okay. And I'm guessing if I expire on the 31st of October, that there are a number of other people are going to have similar dates too. So we probably should not select two meeting dates or anything beyond that until we know who the next.
What is the next meeting date? I don't have it down.
We're working on that, Ambassador Ash.
I realize you all online are unable to hear me if I'm not at the microphone. I'm checking to see if the room is available on September 22nd, 2026. I just had to reconnect to the internet, and it's taking me just a second to determine whether this room will be available.
Tony, if I may, this is John Dunn with the Comptroller's Office. The room is being used on the 22nd of September.
Thank you, John. You sounded like the voice of God from up here.
Well, why don't you go somewhere else, like the State Museum? They'd make it available. There are
Because
legislative committee meetings in the same building you're in right now.
Well, if you want to arrange to have people who will be there and to comply with the recording and posting requirements, I'm all for that. But I'm not for taking that on as my responsibility to get different staff to comply.
Right. I think it's easiest, Ambassador Ash, to use this particular room based on the technology that exists here. I'm wondering if we could just look in that 1 week around the 22nd and not interfering with any holidays. Are you able to tell us any of the availability without us having to pose each specific date? Thank you.
Yes, this is John Dunn again from the Comptroller's Office. The room is available on Wednesday the 23rd, Thursday the 24th, and Friday the 25th of that same week.
Okay. Okay, that's fine.
Let's do the 23rd of September.
Straw poll, 23rd. Any objections?
No objection for me.
All right. How is 10 o'clock Central, 11 o'clock Eastern as far as the time goes?
That's great.
Good.
Okay.
And it'll be September 23rd.
September 23rd at 10 o'clock Central, 11 o'clock Eastern Time.
And that's our next meeting.
That is our next meeting.
So we're going to go 6 months without meeting.
I'd say we'll be meeting 3 times within one calendar year, and that's great compared to the track record of what we've been doing.
We're working our way up.
Yeah. Okay,
The thir-
so September 23rd.
Right, where we'll
So the
discuss,
third meeting this year would come in November, or December?
presumably, but I may not be here. I don't know.
Back to the question about I think it's an important question. The members of this committee that are going to roll off, are those all tied to that October 31st date?
I don't know. Does anybody else know?
Well, don't you continue until you're replaced? That's the way it is on the Museum Commission.
Yes, that is.
I'm not sure about that. What I can assure you is, as far as I'm aware, I would have to look at some things to be 100% certain, but I'm about 90% certain. All of the ones who will be rolling off this year will roll off at the same time and then have that same replacement. They'll roll off October 31st and have the new member assigned to start November 1. So that, though, is generally something my office will make sure happens. So we'll reach out to the organizations who are rolling off members and reach out to the ones who need to have new members nominated, and then comptroller will be the one who finally decides of those 3 nominees.
Ms. Chadwick, would it be fair to say that September meeting that you'll have already initiated that process and be able to provide us some updates on who may be filling those positions?
The process will be initiated by that point. I'm not sure that I would be able to give any insight into the final nominations that comptroller will choose. That usually will happen a little bit later.
And a second question, I think this exists already, but I just want to confirm. There's a central place that lists all the members and when their terms expire,
Yes.
and that can be found.
Yeah, so from the comptroller's office, you would navigate to the Office of Open Records Counsel. There you'll find a link to ACOG, which lists all of the members and when their term expires,
Thank you.
of course.
I got
And if
my
the
link.
member is not, if no appointment is made, does not the current member continue?
I can't imagine that an appointment would not be made.
It happens all the time.
Not with ACOG. I'm pretty certain that the nomination
Well,
or appointment will be
But
made.
if by some chance it didn't happen, does the current member continue?
I don't know.
I'm looking for the statute. I believe, board member, there is a statute that says you serve until you are
Replaced.
Yes. So I think that's
I
what we
think-
need to go with.
I think we found something we agree on.
It's a great way to end the meeting.
I'm sorry, I was saying goodbye to Dan. I didn't hear what you said.
I was telling him, I believe there is a statute that says you serve until you're replaced. I'm just not finding it
you're
in
right.
this 2 minutes.
I know I know in Title 8 for
Yes.
government officials,
Yes.
there is something that in general says that you serve until you're replaced,
Yes.
because that applies to our board members, as
Yep.
in our Tennessee Board of Regents members. So
Right.
that's my understanding of the general law.
We have a member of the State Museum Commission who hadn't been replaced for 5 years, and he still attends meetings.
Sure. Well, we can get that question answered and
can get that
come
question
back
answered.
to that.
And what I heard Ms. Chadwick say is the comptroller is very conscientious about his appointments.
Correct.
Right.
And just looking at that list, my term expires as well in 2026.
Well, it looks like we'll be looking at two new co-chairs. Okay. Well,
Call for
with
adjournment.
is there any other business to come before this meeting?
I
This
just want to
committee.
make clear that for the next meeting, we're going to talk about the bylaws again.
Yes, we got the bylaws, the election of the co-chairs to be effective at the meeting thereafter.
And
I
Brian,
assume.
let me answer this. If come May, a member of this commission came up with a topic that he or she thought ought to be included, how do they get it on the September 23 agenda?
You can email Joel or me, and we can, it's up to the two of us to set the agenda
Right.
as co-chairs.
But I assume you would, within reason, honor any member's request to have a topic included,
Of course,
particularly if it's a month or two out.
Yeah, certainly.
of course. I mean, I don't think our agenda is so packed that we couldn't do that.
Good.
So, okay. All right. Well, any other business to come before the committee before we meet and before we adjourn to meet on September 23rd at 10 o'clock Central, 11 o'clock Eastern to discuss the bylaws and a recommendation for the Office of Open Records Council regarding information that Mr. Christopher is going to come up with, and electing new co-chairs. Without any other business, I declare this meeting adjourned, and I thank everybody for their time, their attention, and their interest.
Thank you.
Thank you.
Thank you.